Welcome, and thank you for joining us for today's program, Maximizing Independent Contractor Models in Massachusetts, Insights and Strategies after Patel and Weiss. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A feature on WebEx. However, if your question is not answered during the session, our presenters will follow up with you directly in the coming days. For those of you interested in CLE Credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated, and it is required for CLE Credit. Copies of the webinar recording and materials will be distributed to attendees following the presentation. Now, I'll pass it over to our presenters for today's program, Barry Miller and Anthony Califano.
Thank you, Andy. Thank you all out there for joining us. Good afternoon, at least to those of you who are in Massachusetts. My name is Barry Miller, and I'm joined by my partner, Anthony Califano. We are both partners in the Boston office of Seifarth Shaw. We are both labor and employment lawyers of a couple of decades of experience. And in the age of hyper-specialization, we are also primarily wage and hour lawyers. And both Anthony and I spend a significant amount of our time and energy litigating issues related to the classification of independent contractors, which is a fairly broad spectrum of disputes, but certainly covers the subject matter that we have pulled together in this webinar here today. And we'd like to think of this webinar, perhaps optimistically, as marking a little bit of a turning point in Massachusetts law regarding independent contractors. For most of our careers, my career and Anthony's career, the independent contractor statute in Massachusetts at General Laws, Chapter 149, Section 148B, has been a real strong lever that the plaintiff's bar has used to make it, in some cases, virtually impossible to classify a worker as an independent contractor without not only a risk of violating the law, but also incurring significant liability, because the independent contractor statute is naturally married up with the Wage Act and other statutory provisions that insert mandatory treble damages for any and all violations. So over the years, we've seen claims, of course, for minimum wage, for overtime, for the reimbursement of expenses, and those claims tend to be brought on a class action basis, because they tend to relate to the classification of a group or category of workers. And for that reason, they oftentimes pose hundreds of thousands or millions of dollars in liability. So the stakes on these issues are really quite high. And up until the last few years, the dialogue around jurisprudence on independent contractors in Massachusetts had been very one-sided. Most of the case law focused on the stringent nature of the test, which Anthony will describe for us in some detail. And we saw the courts applying that test in a way that was very harsh on any entity that retained a worker and didn't classify them as your traditional W-2 employee. And we started to see lots of circumstances that seemed fundamentally unfair, in the sense that the parties intended to set up an independent contractor relationship, and perhaps one that provided lots of benefits to the worker. But nonetheless, when that dispute got to court, the law was always quite harsh on the putative employer and tended to result in a finding that any worker in your stream of commerce was in fact your employee, who is entitled to all of the rights that comes along with being classified as an employee. And one way to think about the content that we've pulled together here is the notion that Massachusetts might have reached a high watermark in terms of just how far the stringent independent contractor test could reach. And we've seen a few cases go all the way up the chain in the appellate courts where plaintiffs have pursued what we might characterize as an extreme theory of liability and tried to press the independent contractor statute to its maximum extent. And in some cases, what they've done is push it beyond the breaking point, with the appellate court saying, that's just too far, our laws don't reach these extenuated claims that you've tried to bring. We're going to talk to you about three of those cases in particular that may signal a little bit of a receding from the high water mark on independent contractor classification, and more importantly, provide some pretty clear avenues that an entity doing business in Massachusetts can follow carefully and minimize one's exposure to all of the parade of horribles that oftentimes comes along with the misclassification of independent contractors. So with that, Andy, you can take us to the next slide. This is an overview of what we intend to cover. As I mentioned, Anthony will walk us through the statute itself and the legal regime we've been dealing with up to this point. We'll then talk to you about these 3 cases we've highlighted, and we'll break those down into some practical tips that you all may be able to at least consider or potentially apply in practice as the law continues to develop in this area. With that, I will turn it over to Anthony, and I think we are ready for the next slide.
Please. Thank you, Barry. Thank you, Andy. Hello, folks. So first, it makes sense for us to start with what the law is, what the statute that we're talking about says, and then to think about the cases we're going to talk about in the tips in the context of the statutory regime. Here, we're talking exclusively about the independent contractor standard that applies under the Massachusetts wage and hour laws. To be clear, there are different standards that apply under different statutory and common law regimes, so it's important not to assume that this standard that we're talking about applies in every context. This applies in the wage and hour context. This statute is baked into the wage and hour statutory regime, okay? And for those who cannot see our slides here, I'll cover it, the content quickly, but this is our wage and hour applicable independent contractor standard. And if, and I emphasize if, it applies, the burden of proof is on the putative employer. There are 3 parts to it. They are in the conjunctive, meaning that the putative employer needs to satisfy, has the burden of proof to satisfy all 3 components. Failure to meet even one of them results in a determination of employment status and then the damages that come along with that. Prong 1, or prong A, as it's referred to commonly as the ABC test, is the control standard. The individual must be free from control and direction in the performance of the individual service, both under contract and in fact. So here, in prong 1, there is a baked-in assumption that there is a contract. Obviously, contracts can be both written and be oral, but there needs to be a contract, and the individual needs to be free from control under the contract and in fact. Okay? Control, there's a number of different factors that implicate the concept of control, like supervision, instruction, dictation regarding location, schedule, hours of work, disciplining the worker, mandating various uniform and dress code requirements, providing tools and instruments for the work, etc. The list goes on. And there's overlap among the various prongs. Prong 2 is one that's often most difficult for companies that try to utilize independent contractors, and that is the usual course of business prong. What that means has been the subject of a lot of debate. Some have argued, in this case law reflecting that the usual course of business means that the service provided by the individual is necessary to the service provided by the putative employer. In other contexts, we've seen it referred to as the usual course of business is something that's regular and continuous part of the service provided by the putative employer. Under other standards, including a different standard applicable in Massachusetts, this prong B, this prong 2, has a multi-part test. Here, this is it, usual course of business, and that is often a difficult one for putative employer to establish. And then third, or the C prong, is that the individual be customarily engaged in an independently established trade, occupation, profession, or business of the same nature as that involved in the service performed. This is really reduced to the concept of independence. Is the individual providing work holding themselves out as being able to provide their service to other businesses, other individuals, other entities, or does the individual rely exclusively on an engagement with one particular business entity for their service? And so that is the standard, right? And you can see how that independent standard at prong C overlaps somewhat with the control standard in prong A. Some would argue that that absence of independence, where there's an exclusive engagement, results in financial control as opposed to activity type control. And so if this standard applies, it is an exacting and a stringent standard for the putative employer to comply with. And as Barry alluded to, historically, in cases, plaintiffs and their attorneys, and in some cases, the case law is you sort of read it as sort of assuming that this standard applies. And the cases that we're going to talk about have corrected that fallacy in the law. And we've intentionally left out from this the language in the statute that comes right before it lays out this standard. And that language creates this threshold question of service that we're going to come back to in a few slides down the road. But this is the beginning of the framework that we're talking about. We can go to the next slide. Okay, why does it matter, right? Well, the consequences are why it matters. Obviously, we want to make sure that y'all are doing your best to comply with the law, but the consequences are, as indicated by Barry, significant liability and, more practically speaking, sometimes significant exposure, including the concept of mandatory treble damages, which in recent years has become a problem of its own because of how stringent and non-forgiving the law is that requires triple damages, even when there's a good faith mistake, even a good faith mistake made by some individual entity other than the arguable employer. Triple damages are the norm here. But the consequences of misclassification are even greater than just that, right? We've got unpaid paid wages, including overtime, minimum wages, but oftentimes now what we're seeing is even where the wage-related damages are limited by virtue of the nature of the engagement, the other types of damages can mount up, and those damages relate to expenses associated with the work that the worker incurs as opposed to the business, the benefits that the individual worker would have reaped had they been treated as an employee of the business. And we can't ever forget how under our wage and hour regime in Massachusetts, attorney's fees, costs, and interest are the norm, so significant damages. And then there's the notion of liability associated not with the plaintiffs and the plaintiffs' lawyers who assert claims, but government entities who have a vested interest in ensuring that individuals that are providing work, doing services are classified properly. Taxing authorities, the Department of Unemployment Assistance that oversees unemployment insurance. These government entities can and do audit businesses and are looking for misclassification so that they can secure the taxes and contributions that businesses, if employment were the case, would have been withheld, would have been paid as it relates to the individual workers. Then, of course, there's the consequence of bad publicity and the theoretical possibility of criminal sanctions and penalties. So the danger is real, which sort of frames why it is that we consider this an important topic to discuss and why it might be important to your businesses. We can go on to the next slide. We're gonna go on and pass it back to Barry. And while we don't want generally like to do webinars or discussions that simply include a regurgitation of the facts and the conclusions in cases, we view this as somewhat different. These are case studies, right? And so we're going to provide you with some sense of the facts underlying these cases that resulted in favorable conclusions for businesses because the case studies offer some decent insights that you'll start to see as we discuss them, but then we'll circle back to after we cover them. Go ahead, Barry. You're muted, bud.
Thanks, Andy. You can go ahead and take us to the next slide if you would. And I'll reiterate something that I said at the beginning, which is we're going to talk to you about several cases in which the very stringent standard that Anthony's just described was determined not to be the right standard, or a finding that the worker at issue simply wasn't providing service to the defendant entity. And there are a few ways that that can be queued up. The first case we're going to talk about is Jinx versus Credico, which was decided by the Supreme Judicial Court in the last few days of 2021. And it was arguably one of the first cases that began to reverse this trend. Fundamentally, it concerned a bid by a group of plaintiffs' lawyers to sue not only the entity that had retained the workers that these plaintiffs' lawyers represented, but a downstream entity in that organization's stream of commerce. To break it down a little bit, Credico, the defendant, is a broker of sales campaigns. So they set up face-to-face marketing, whether it's door-to-door or in retail locations, for various products, including cell phones, cable TV, lots of different things. And they provide those services nationwide by working with local companies who retain workers to do the face-to-face marketing. And plaintiffs contended that this entire regime was subject to the ABC test that Anthony described. And fundamentally, they contended that because these workers who were doing door-to-door sales were in the usual course of business of this entity that was several steps removed from them in the chain of commerce, that they were employees of that downstream entity just by operation of the ABC test and Section 148B. And over again, in attempting to press that argument, they followed a theme that we see in some of the economic literature relating to fissured industries and the notion that people are becoming separated from the product of their work. And they were asking the court to follow the money, follow the money, follow the money. And the notion was that if as an organization you benefit financially from the efforts of a worker, even if that worker is removed from you by several intermediary organizations, that worker is your employee, entitled to everything that goes along with that status, from minimum wage to travel time to earned sick leave to all of those sorts of things. And the SJC was very skeptical of that approach. One thing that Justice Kafker said at the argument in that case, I think in some ways captures the vibe of the three cases we're going to talk about today. Justice Kafker said to the plaintiff's counsel that Massachusetts has a reputation for having very stringent wage laws. That's on purpose and that's by design. But part of that design is the notion that each worker generally is going to have one employer, and you're not entitled as a worker to treat every entity that is in the same economic stream as the entity that hired, supervised, and paid you as your employer. Fundamentally, plaintiffs were asking the Supreme Judicial Court to adopt the ABC test as the standard for something that we call, under federal law, joint employment. And the SJC rejected that directly and declined to adopt that sort of standard where you have multiple businesses involved in the potential employment of a worker. And consistent with Justice Kafker's statements, they said that where there's an intermediary organization that hired and retained the plaintiff, we're going to essentially adopt a federal standard for determining whether another entity that also had some interactions with the worker can be responsible for the wage-related obligations of that worker. And one thing that is important in the SJC's analysis there is they footnoted the notion that this framework that they've announced as the new standard for joint employment in Massachusetts doesn't apply in a circumstance where the putative employer has set up an intermediate entity as some kind of sham. It has to be a real, legitimate, and independent business. And at least as a practical matter, the defendant in a wage case is going to have the burden of proving those things, that there is an intermediate and genuine employer, and that it's a real business and not some sort of artifice created by the defendant to avoid liability. But where the employer can show that, the SJC has said that it will respect the corporate form of the entity that hired the worker. And what that means is that the downstream entities, the Credicos, the cell phone makers, the cable TV providers, are not liable for efforts undertaken by workers with which they had no contact. That's only going to be the case where a downstream entity has exercised the power to hire and fire the worker, has exercised considerable control over the worker's schedule and terms and conditions of employment, determined what the worker is going to be paid and how, and maintained records of all that. Essentially adopted the worker as its own employee. But in the absence of that, this worker is a stranger to a defendant entity like Credico, and that entity can avoid liability under this new standard. I'll pass it back to Anthony to talk to us about the two other cases that are on our radar today.
Thanks, Barry. So Patel v. 711 is sort of, well, it follows the Jinks v. Credico decision. Patel has made it to the Massachusetts Supreme Judicial Court a couple of times now, and the decisions in each time are worthy of note. Patel is a case that involved franchisees, independent franchised owner-operators of 7-Eleven convenience stores in the Commonwealth of Massachusetts. And the dynamic in this case is different from the dynamic in the Jinks v. Credico context in the way that's noteworthy because it involved a direct relationship between the franchisee and the franchisor. So it was different. It didn't involve this downstream multi-tiered relationship that you had in Credico. Nevertheless, it offers an interesting case study and helps in its confirmation regarding certain important legal principles. So in what I call Patel 1, the Supreme Judicial Court actually held that the ABC test for determining independent contractor status applies in the franchisee-franchisor context if there is service performed by an individual worker for the franchisor. So where a franchisee is an individual performing service for a franchisor, the ABC test applies, okay? Stated differently, or rather so. If the franchisee is not an individual and or is not performing any service for the franchisor, then the ABC test does not apply. While this is unique to the franchise context, this decision, the legal principle that's really at stake, at issue, is applicable beyond the franchise context, and we'll see that a bit later. So there's that initial ruling, and then Patel makes its way back to the Supreme Court earlier this year, and there the Supreme Judicial Court held or affirmed that franchisees do not perform, these franchisees at least, do not perform any service to the franchisor within the meaning of the independent contractor law. Despite the need to run a business in accordance with a franchise agreement that has some requirements that plaintiffs have argued are the sort of requirements that look and smell like control. The SJC disagreed. And some of the examples that you might guess are commonplace in the franchise context would be, hours of operation, right, dictated by the franchise agreement, products being sold, how they're merchandised, uniforms, for example. These are things that plaintiffs and plaintiffs' lawyers would argue are things that reflect control by the franchisor or putative employee over the worker. And the court in Patel said that the mere financial gain does not cut it, right? It explores sort of the concept of service. And in that context, the court said, distinguishing between legitimate relationships requires examination of the facts of each case, and that begins with this threshold determination of whether there is service performed by the individual worker to the alleged employer, okay? That threshold is not satisfied merely because the relationship between the parties benefits their mutual economic interests. It also is not, the concept of service is not satisfied or present simply because the parties are operating under a governing agreement that lays out their respective rights and obligations, or where the parties are complying with regulatory requirements that result in the franchisee, aka worker, doing certain things that need to be done that might in a different context smell like control. So that is an important part of these two decisions, right? So we have at least one case where a court said that an individual, and these franchisees in some cases were individuals, in other cases they were set up as businesses, that this ABC test does not apply if the individual is not performing service. And then this is an example, a case study where the court actually agreed at a very high level, our highest court in Massachusetts, that these franchisees were not providing service. Frankly, one could argue that it was the other way around. The franchisor provides a service to the franchisee, and in exchange, the franchisor receives some amount of compensation, whether it's royalties, whether it's a percentage of profits, or what have you. That does not result in the notion, at least under this law, that service is being provided by the worker to the company that's the alleged employer. Okay? This language, I want to emphasize and go back and emphasize it here that we quote, that we emphasize here, is the language that appears before the ABC test, right? And so before you work to the ABC test, the statutory language is this: for the purpose of our wage and hour laws, an individual performing any service, except as authorized by this chapter, shall be considered to be an employee under those chapters unless the putative employer satisfies the ABC test. This threshold concept, the SJC's now has confirmed several times, is an initial burden, and that initial burden is on the putative employee, whereas the burden of satisfying the ABC test, if it applies, is on the putative employer. You can go to the next slide. All right. Weiss is another recent decision, this one by the Appeals Court of Massachusetts, that I think sort of marries some of the legal principles from Jinx and from Patel. In Weiss, the plaintiff was a software engineer, and the defendant was an investment firm. And this individual engaged via two business entities to provide service to the defendant. And the decision actually acknowledges that the individual, Weiss, provided service, but that didn't end the inquiry. What the court said in that decision was noteworthy. So I'm going to read it. It says, where an individual provides service directly to the putative employer, the application of the statute is straightforward. They're presumptively employees unless the employer, carrying the burden of proof, proves that the three separate prongs of the ABC test are satisfied. However, the appeals court said, the situation becomes murkier when the individual provides service to the employer through an intermediary entity. In such circumstances, the individual may not have standing to pursue a misclassification claim because the statute was not intended to bar legitimate business-to-business relationships. The question is whether the corporate form of the intervening firm represents such a relationship or instead is one whose raison d'etre is to prevent the classification of workers as employees. In other words, the reason, apologies for my French pronunciation, the reason for the relationship is to avoid the statute. And so in Weiss, the court acknowledged the threshold burden of the worker to prove that the worker was an individual providing service to the defendant business entity. And there, the individual had established a corporate business called JSOL. JSOL engaged with a staffing company, and the staffing company engaged with the defendant. And the question presented to the jury in that case was whether or not that dynamic, either both or alone, those intermediary business entities was a business standing in its own right, a legitimate business. The court asked the jury to decide, and the question confirmed that the individual was not providing service. And here's how the question was presented. Did Weiss provide service to Loomis through a legitimate business-to-business relationship with either the staffing company or his own business, or those businesses created and or maintained for purposes of misclassification? And the jury answered that question no, and the appeals court affirmed the decision. And so the court said that there were some relevant inquiries in deciding whether or not there was a legitimate business-to-business relationship, including whether the individual provided or the individual's business provided services to others, or made itself available to others. Did they offer the same or different services? Did the individual's business operate on its own initiative or because the defendant had required it? Those were important inquiries into establishing whether or not this individual service requirement had been met. Okay? Next slide, please. So with those case studies, Barry and I get to thinking about what does this mean for our clients? What does this mean for businesses out there that are attempting to comply and would like to maybe consider and reevaluate their independent contractor relationships if they exist or they're considering pursuing them? And we think that there's several takeaways that are potentially good tips to consider if you want to shore up an independent contractor relationship. And we think that stemming from these decisions, some of those are listed here. One is to engage with businesses, right? Whether the business consists exclusively of an individual who's incorporated and undertaken to create a business because of their desire to be an independent business entity is important. So choosing to engage with a business as opposed to an individual serves to achieve the goals of the statute, the independent contractor statute, and should hopefully help to satisfy what the SJC has said is needed. Paying the business entity, not issuing payments to the individual, is another good step to consider. We know from experience that government entities that are conducting audits oftentimes will ask a business for its check register, right, to see if the business is making payments that are not wage payments, that are not payroll payments from which there are deductions to individuals, right? So payments to business entities don't smell like employment. As comes from the Weiss decision, not forcing an individual to create a business is helpful, right? The individual needs to be the one that decides that they want to have a legitimate business. And so deciding to engage with a pre-existing corporation rather than saying to somebody, you know, go start a business and then we'll engage with you is a safer approach. Engaging on a non-exclusive basis, as hinted by Weiss, is another good approach. If the individual's business relies exclusively on yours for its compensation, its economic viability, that's less powerful than the alternative where the independent business engages with other businesses, so it's not exclusive, right? And another way of saying that is non-exclusive is that these individuals, these businesses do work for other businesses, other individuals, thus confirming their independence and their legitimacy. Pass it back to Barry for a few more practical tips. Next slide.
Thanks, Ed. Just a few more tips that are all sort of aligned with the points that we've discussed in terms of the takeaways of these cases. One focus in all of these cases is what the putative employer does and how that relates to the efforts of the independent contractor and any intermediate entity that may be between the worker and the defendant. And so typically, for example, if you're an accounting firm, you're not going to want to enter into independent contractor relationships with accountants. That's going to be difficult for you to explain in terms of the separation between your business, not just because of the second prong of the independent contractor test, but because you want to be able to show that the entity that you've retained does something different than what your business does on a regular basis. And in the cases that have been decided up to this point, the courts have given defendants, organizations, quite a bit of latitude to define what their business is, what their raison d'etre, to borrow Anthony's perfect French articulation, would be. And so you may even want to build that into your contract, a definition of what the contracting organization does and how that relates to the vendor's efforts, and an affirmative statement that those things are different. That will give you a good starting place for the defense of an arm's length relationship that will survive scrutiny under the independent contractor test. Related to that is you're going to want an agreement that defines the roles of the parties. And one misstep that a lot of organizations make there is to insert too much control for themselves in those contracting documents. To the extent that you're retaining a vendor, an independent contractor, and you're thinking about incorporating terms in those documents that are going to affect the contractor's behavior, the downstream worker's behavior, you want to pause and think about whether and to what extent you really need those items of control and whether they need to be included in the contract, because every item of control that you include in a contract will be held against you. So you need to be thoughtful about that. And of course, you want the usual recitation that the parties intended this to be an independent contractor relationship. And you might meet those up with some descriptions of what the vendor is. You might note in your contract that the vendor has relationships with other clients in the way that Anthony described and is free to continue to do that. So that covers the points that were on the slides. We also had a couple of secret ones that we didn't put on the slides. One is you may want to consider arbitration agreements with any individual workers who you're engaging in a manner that may be susceptible to characterization as an independent contractor relationship. That is not a simple issue by any means, and there may be other potential points of exposure that arise from having folks sign arbitration agreements, but it should at least be on your checklist of things to think about, because it's your best chance of avoiding a class action challenge to how you've classified folks. And then the last secret bullet point is you really have to vet whom you're doing business with. If you're entering into relationships with fly-by-night contractors that are not well established, that are not taking care of their employees in the way that the law expects them to, you're going to be subject to challenges. That's not so much a legal observation as a practical one, but it's one that's born of decades of experience in the trenches litigating this stuff. And it may be the single most important message that we have for folks. You can't think that any of the legal tools that we've given you are going to allow you to treat a person or entity as an independent contractor if that person or entity simply is not sufficiently established to do business for themselves. You need to really think about that stuff. Those are our tips for today. We'll go one more slide, which I think has the CLE code for today's presentation. We hope that you all found it informative. I'll read the code out loud for anyone who may not be able to see the tiny letters on the screen. It's SS, as in Saifar Shah, 3969. That's SS 3969. And thank you all for joining us this afternoon, and we hope you have a great day. Thank you.
Thanks, folks.